Hello everyone and welcome to today's Mondac webinar in association with AZB and Partners, in which we will be highlighting issues relating to fraud and asset tracing in the context of international arbitrations, insolvency and bankruptcy and white-collar crime. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Vijay Endra Pratap Singh is Partner and Head of Litigation at AZB and Partners, Delhi. Vijay Endra has spearheaded various arbitrations pertaining to the validity of shareholder agreements, option contracts, long-term supply, and claims on account of cancellation of coal blocks, confidentiality, and franchising and intellectual property issues. Anandita Roy Chowdhury is a partner in the disputes resolution team at AZB and Partners, New Delhi. She specializes in insolvency, bankruptcy, and debt recovery laws. Abhinay Jha is a partner in the dispute resolution team at AZB and Partners. Abhinay graduated from the National University of Judicial Sciences, Kolkata in 2013 and holds a Master of Law degree from the University of Cambridge. Before I hand over to the panel, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. We will endeavour to answer as many questions as possible during our Q&A session, but please do reach out after for any additional information you may require. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thanks, Dan. It's great to have a chance to speak with you on this topic. I think it's a topic all of us get quizzed on quickly, as well as a topic that engages and keeps awake CEOs at night. It's in this context that we need to figure out effectively what is fraud. And I think the best way to sum it is it's the opposite of knowledge is not ignorance, but fraud and deceit. And it's with this that law seeks to address the issue of deceit and or conflict with respect to what it calls a basic minimum proprietary behavior. To deal with the topic today, we will break it up into three clear buckets. Bucket one, which is the IP, which is the white collar piece, which I'll be dealing with. Anandita and Abhigyan, of course, will deal with more honorable men. They are going to deal with the IP and the arbitration piece around here. And while we deal with these topics, please feel free to share with us any questions that you have. We are happy to address them on the seminar, it's a webinar itself, or get back to you subsequently. If you would drop us a mail, our details are available with the organizers or are available widely on the net. With this, may I just get Aaron to move to the first slide, please? Thanks. So as good lawyers, you should always start with, well, what is the definition of fraud? It's a term used more freely than explained. And the reason for that is, if you were to search for the definition, you'd be surprised to find that our general law, which is the IPC, does not define fraud, but defines fraudulently and deals with fraud-like situations when it deals with issues of offenses such as cheating, forgery, or criminal breach of trust. So where does this definition come in from? It comes in civil law under the Contract Act, and Section 17 of the Contract Act, or the Indian Contract Act, provides for the same. But what has been actually a game turner has been the need to recognize, deal with, and action effectively corporate fraud, and that has been brought in through the definition that is provided under Section 447 of our Companies Act. In addition to the Companies Act, we also have SEBI providing for a definition under the prohibition of fraudulent and unfair trade practices relating to securities market regulations, for a definition which is very similar. So the good part is that while you can find three sources for it, you actually have what I call four crucial ingredients in this definition. And what are the basis, whether you make it under criminal law or any regulatory or criminal or civil law? There should be an intention to deceive another person. You should gain or attempt to gain at least an undue advantage or injure the interest of another person. The basis for such deception is usually an act, omission, or concealment through a false statement which is known to the maker that it is false. And it is not important that you seem to have actually obtained some gain or you have prevented a windfall loss. So the law clearly says that for any dishonest, fraudulent misappropriation of property or conversion of property, it should be done in a manner that results in the intention to deceive, and which property would not be handed over or an attempt to hand over would not be possible unless you were making a false or a dishonest statement. The law is very clear that it doesn't really help if you gain from it. It pays you for, or it visits you with consequences irrespective of your gain. I have the next slide. So how does the Companies Act, let's say, deal with this? And let's start with the Companies Act, because I believe corporate fraud is something that effectively has been catching the imagination of a lot of people. And it's got to do with the fact that we are in recessionary times. And in recessionary times, the one thing that you do find out is the waves go down. And you suddenly realize how many people are only swimming with their smiles. And that's exactly what the Companies Act tries to prevent. It tries to bring about a certain degree of diligence. And how does it bring about this diligence? It says that the directors, who are the guardians of a corporate entity, share a responsibility to create and certify adequate internal financial controls exist which enable the prevention and timely detection of fraud and other irregularities within the company. This is provided under our section 132. So the first thing is positive monitoring. The second is that you may find that the occasional guardian goes off to sleep. That brings in a second line of check. And that second line of check is with respect to the auditors, showing a certain degree of skepticism when they look at management feedback on how things are. And I don't know if most of you are familiar with this movie, 3 Idiots, where there was a blind night watchman who used to keep saying all is well, and everyone would sleep away, thinking all is in fact well, is not the standard that the law requires. The law says that you have an obligation not only to listen, but you have an obligation to hear and see. And it tries to do so by ensuring that you detect fraud, not only by way of a degree of skepticism, but you have to also ask the management for its answers. And if they do not give satisfactory answers, you have an obligation to escalate to the central government through a special fraud reporting. So now you've got 2 gatekeepers, one at the board level, the other with outside board, but nonetheless forming an oversight. The law finally also provides that these may be periodic, these may be actually annual exercises. So that may not be an effective check. So the law prescribes that there should be periodic disclosure and monitors the same through designated compliance officers, which is provided for under 204 and 205. What's interesting is that the law for the first time recognizes the important role that company secretaries play in the law in ensuring that there is due compliance, and the concept of a compliance officer has gained prominence with the law trying to seriously address the issue of fraud, because you have to realize why this is important. Our law, when Satyam happened in India, was woefully short. And as a result of which, you do see what I call the Satyam corrections. And I call these 3, the Shivam and the Sundaram, following Satyam, as the way to get things right. Karen, can I have the next slide, please? So how do you deal with fraud? It's very nice that you have corrective measures, you have an obligation and a duty to deal with this. But what happens when the gatekeepers sleep and when all is in fact not well? The Act provides as a complete code various actions that can be taken. And what's interesting is it provides different avenues to get and address the issue of fraud. And I call that the act of dealing with, or not just fraud, but also malfeasance and misfeasance. And it does so through multiple routes which are available to different stakeholders. And I've just listed out a few of them. The first that is available is the traditional oppression, mismanagement, and prejudicial conduct or unfair prejudice route. The original force versus hard bottle rule got captured into our law, but our law went further. And as a result of which, it cast an obligation to ensure that conduct is not in a manner detrimental to the interests of the company and its stakeholders, and therefore held and holds responsible the company, shareholders, key managerial personnel, and the people who can ask them to account are the shareholders themselves or even the central government, and that's what you've seen in ILFS. The next thing that you would see is the class action provision, where you can have the action not just against the management, and that's very interesting. There's a wider net cast which goes to the company, its directors, but also hits its auditors, advisors, and consultants. So anyone who has been a part of the party effectively has to pay their bill. And that's exactly what it does by asking for various kinds of cease and desist orders, and we'll deal with that a little later, as well as damages for people who are involved in acts which can trigger the class action provision. But in addition to this, what the law really makes a change on is it finally creates a serious fraud investigator, and that is the Serious Fraud Office, Investigation Office. It's a prominent investigator with respect to investigating frauds, and is in fact someone who's been given the mandate to take the primary position with respect to corporate frauds, because all other agencies have been asked to stand down. Not only have they been asked to stand down, they've been told that the SFIO will give you information, so please do not start parallel inquiries. This shows not just a commitment towards actioning fraud, but to ensure accountability and consistency. In addition to the SFIO, you've had a situation where you have an application possible under section 140 subsection 5 for removal of auditors for fraud, and this can be done by the tribunal, which is the NCLT, suo motu, or be filed by the central government or any person concerned. So if you have an auditor who's a hand in glove with people, you will be able to get the auditor removed even before the auditor's term comes to an end, and the law provides an actionable way to do so. In addition to that, the traditional investigation powers still continue to exist with the central government under Chapter 14 of the Companies Act, which also give the government significant powers with respect to prosecuting any fraudulent activity. And may I have the next slide, please. So what is it that is possible with all these various powers to touch and seek redressal? You have multitudes of reliefs available. The reliefs can be in the form of those in O&M or oppression and mismanagement, which comprise of specific directions to recover undue gains, removal of directors or KMPs, and declare whether a person who has been acting as such is fit and proper to hold the job, not only in this company, but for all companies. That's very important. In addition to this, there are cease and desist orders which are possible, as well as orders to regulate future conduct in a manner that is just and equitable. But most importantly, all of this is to ensure that it brings an end to the matters that have been complained of in the petition. As regards class actions, that's the 245 actions, you have the ability to seek investigations as well as orders for damages and disgorgement of benefits. And here you may see principles similar to those that the SEBI employs being used for disgorgement of benefit. As regards the investigation by the central government, the powers available include the power to freeze assets during investigations in case of egregious default, or where there is a a sense that nothing will be available if things are allowed to continue. May I move on to the next slide, please? The next set of reliefs, as I mentioned, are against the auditors, and these are the guys who've really been hit under this act, because in case an auditor is found complicit in fraud, the auditor, in addition to facing the actions for prosecution, would also be held to be ineligible to be appointed as an auditor in any company for a period of 5 years. So you effectively have a blacklisting summary procedure to ensure that a wrongdoer does not get involved with the affairs of a company. In addition to that, they will also be prosecuted under 447, which is the prosecution for fraud brought in under the Act. The removal of directors in case of failure to disclose conflicts has been reinforced with multiple provisions providing for the same, because they believe that a fiduciary should not and cannot compromise his or her duty to a company. The last thing is that when you've created the SFIO, you've given it prominency, you need to give it a special mechanism and a special machinery. And that's been done by providing the SFIO with a special judge to look at the issue of commission of offences under the Companies Act, and in particular fraud. And a special designated court exists, which is to deal with these offences and can punish people to a term up to 10 years with a minimum mandatory sentence of 6 months for offences which don't involve public interest, or 3 years where public interest is involved. In addition to that, there is also a hefty fine involved, which is to be equal to not less than the amount involved in the fraud, but can go as much as 3 times the amount in question. And have the next slide, please. In addition to, and may I have the next slide, thank you. In addition to the issue of fraud under the Companies Act, you have the traditional issues, or the general law also dealing with fraud, but it deals with it in the form of breach of trust, cheating, or forgery. And one can deal with this conduct provided that the ingredients are satisfied, and one can prosecute under the general law. However, unlike most of the special laws that we know of which provide for vicarious liability, IPC does not provide for vicarious liability, and there may be other ways to reach out to wrongdoers in a company, which is common intent, criminal conspiracy, abetment, and common object. This is how you reach out to gangs of thieves, rather than holding up office alone being enough. And if you are to reach out to someone, you have to attribute roles, so you have to give them something in their personal capacity. IPC also allows for the police to seize property that may be involved in the commission of fraudulent offences, and in particular allows them, may I have the next slide, to seize stolen property and deal with any property which they have found under circumstances which create suspicion. Such property can be movable only and not immovable property, so they don't have that power. They can compel production of documents, including from banks and financial institutions, and to do all that is required for investigations, inquiry, trial, and other proceedings. This includes sending requests out to foreign countries through letter rogatories. Successful prosecution leads to terms which may extend to life sentences in certain cases, and could also include terms for someone who tries to destroy documents and or prevents production in legal proceedings. May I have the next slide, please? In addition to the IPC, we have a special kind of conduct dealt with under the Prevention of Corruption Act, which enables us to reach out against public servants and deal with their acts under the issue of bribery and misuse of office. And this is primarily on the fact that they impact public interest and public trust. However, to ensure that there is no prosecution which is for frivolous reasons, there's an authorization to prosecute which is required, and ensures genuine complaints can go through. May I have the next slide, please? Because of the nature of the beast, it can only be brought against, such a complaint can only be brought against public servants, but can also involve commercial organizations which bribe public servants, which could include partnerships, corporate entities, whether incorporated within or outside India. And these are usually matters that are handled by specialized investigative agencies such as CBI, the anti-corruption bureaus, as well as the Lokpal and the Central Vigilance Commissions, which are special mechanisms with respect to dealing with property in life. There are special courts established for the designation for taking on fast-track adjudication in prevention of corruption cases, as well as ensuring that this is not something that is taken lightly. Have the next slide, please. There is a negative or a reverse burden of proof against the public servant, that once the essential ingredients are fulfilled, then in such a situation, it is important that the officer concerned answers the question rather than one having to place the entire offense out. There's equally a presumption that when there is an actor for a particular commercial organization acting on behalf of that organization, that they act properly. And there's a presumption that he acted on behalf or she acted on behalf of the organization. So you can't hide behind rogue actor simplicity. Lastly, you need to take adequate procedures in compliance with guidelines to prevent bad conduct, and you need to have some kind of a compliance policy in place, which may be at least a first line defense. Have the next slide, please. When we've dealt with the root, let's deal with the fruits, and the PMLA does or deal with that. And in such a situation allows for reaching out to the fruits of fraud, provided it arises from designated offenses through proceeds of crime. These ensure that no fraudster can benefit from their wrong. I'm not going to get into the definition because I'm running out of time. Moving on to the next slide. The PMLA allows the ED to summon the accused or any person with the knowledge of assets to depose on oath. It allows for wrongful information to be actionable with penal consequences and deals with attachment through a set of rules that are there, and in particular deals with managing such property and maintaining such property. In case the property is of the nature of a depreciating asset, the court can allow monetization of the same to retain maximum value and keep the value with us. Next slide, please. The last thing that I want to deal with is the issue of crypto. Now, crypto has been the mystifying Indian rope trick because it's difficult to see how it goes up, and you can never figure out how far it goes up. And that is the essential nature of the beast of decentralized finance, because it does not have regulatories or intermediaries which are regulated intermediaries or regulators which can verify for the asset tracing on the entire chain. And at times, in fact, gives anonymity a certain premium. India has recently introduced a requirement for reporting and maintaining records in exchange of or of an exchange of virtual digital assets, which includes crypto, and has asked for reporting on this regard and expanded the scope to ensure reporting. There is a significant issue with respect to whether attachment of the public ledger can be done effectively, but that is something that you are looking at being addressed in a serious manner by the law itself. The next slide, please. The Minister of Finance has recently stated in the Lok Sabha that with respect to crypto frauds, they have in fact taken on and attached amounts equivalent to about 936 crores. And in this regard, they are pursuing crypto not just from a criminal point of view, but also from a foreign exchange management point of view, because we're an exchange control country, and anyone that breaches exchange control has also equally to answer for it. Therefore, the KYC standards are being pushed with greater degree by RBI, as well as through the reporting under the PMLA rules, as well as ensuring that there is a larger mindfulness of the anti-money laundering obligation, to which extent you've had tax collection at source being added in addition to KYC requirements. And with having overshot my time significantly, I'm now going to hand it over to Anandita to try and make it up with whatever time she has left. Thank you, everyone.
Well, you really can't say much, is it? When the head of practice shoots the time limit. We also have appraisals to deal with at the end of the year. So good evening, everybody. We'll try to keep it short. It'll be a snapshot of what fraud and asset tracing is all about under the Insolvency and Bankruptcy Code. and I will have to keep it short because I also have Abhigyan on this call to also let you know about the same, but under the Arbitration Act. Okay, so Insolvency and Bankruptcy Code, it's a change in mindset, it's a change in thought process, it is an entirely different legal regime. Started somewhere in 2016. We are today in 2023. A lot has happened, a lot is yet to be done. First and foremost, when you talk about Insolvency and Bankruptcy Act, what one needs to remember in India is this, that you're not looking at in the typical sense of winding up and winding down business operations and thereafter moving into liquidation. The idea is to first take a distressed company and thereafter try and resolve it and possibly hand it over to somebody else who can well look after it, and in the process also puts in that money where the creditors of the distressed company can go back home happy and at least recover something out of it. All right. In the process, you also ensure that employees and other creditors involved or other stakeholders also sort of are taken care of. There are resolution plans that take care of all and sundry, and sometimes it does not happen. But be that as it may, what one needs to remember, the reason that you also have protection and assets to be traced and brought back into the fold of a distressed company, or rather we'll call it the corporate debtor for the purposes of the Insolvency and Bankruptcy Act, is to sort of preserve it, protect it by a resolution professional who is actually a third party, his or her appointed by an order of the NCLT, to take forward the process and eventually hand it over to someone else. So an insolvency proceeding or a resolution process can never be complete until unless you actually catch hold of the assets of a corporate debtor. Now, certain companies maintain great books. You go through them, you find out what are the assets that there are. Now, very interestingly, what you need to remember, while most of the laws are restricted to within the jurisdiction of a country, insolvency also actually provides the power to a resolution professional to not only take control of the assets that are within this country, but also to reach out to assets of the corporate debtor that may be outside the country, which obviously gets us to cross-border insolvency, but we'll come to that in a little while. Now, in order to do all of this, obviously the resolution professional has a tremendous task. Now, how do you achieve all of this? You have one resolution professional as an individual who's appointed. Once the resolution professional takes charge of the corporate debtor, it thereafter goes looking and hunting and tracing for the assets of the company. Books of the company, definitely. You may also find some stray information or stray documents. So how do you go about actually protecting it? Not only do you take charge of what is already available, but it is also made mandatory on the resolution professional to actually also look at contracts, also look at various arrangements that a corporate debtor may have undertaken before it went into insolvency, which in turn has actually denuded or taken away value from the corporate debtor, right? So, which means you're looking at contracts, you're looking at certain contracts which may possibly in the nature of preferential transactions, undervalued transactions, extortionate credit transactions, or transactions defrauding creditors and fraudulent/wrongful trading. We'll first deal with these set. So for anybody who actually wants to pay attention to the sections, they all start at section 43 in the Insolvency and Bankruptcy Code, and they go all the way up to 51, and thereafter again section 66 and 67. And for the criminal consequences, which you can see on the slide, you're looking at section 68 and 69 and 70. Now, as far as preferential transactions, now what you need to realize is they are very heavy provisions, okay? So there's a lot of detailing within the provisions itself. You can apply the tests and thereafter see where it goes. Now, mostly in a practical sense, I know that all of you may be reading all the provisions, but practically what actually happens is that the resolution professional actually appoints a third party to do a transaction audit. Now, this transaction audit actually encompasses a very detail-oriented study of all transactions that have transpired right before the insolvency starts. So assume you're looking at 1st April 2023, you have to go back 2 years in point of time for preferential, undervalued, and extortionate credit transactions. assuming that those transactions are with a related party. When it comes to transactions defrauding creditors, and you see the word is fraud, right? So wherever you see the words transactions defrauding creditors or fraudulence/wrongful trading, there is no time period, because at the end of the day, there's an element of fraud, which is why you do away with these limitations that are set forth otherwise. For unrelated party transactions, okay, for that, it is a period of 1 year. So you back calculate, which is why sometimes they're also called clawback provisions. Now, what do you do? The RP, the resolution professional, appoints an independent party. They go through all sorts of contracts and arrangements, and then they have to start bucketing them. More often than not, in practice, we've seen that the transaction audit reports are made in such a way that they actually do not highlight or segregate what were preferential, what were undervalued, and what are extortionate. Now, that is something, I don't know if there are any resolution professionals or any transaction auditors who have joined this session, but it is very important to actually apply oneself and bucket them as preferential, undervalued, extortionate, because the nature of the orders that you seek when you're clawing back monies that have actually gone from the company sort of also differ depending on the nature of the transaction. So there are also judgments of the NCLT and the NCLT as on date, which have actually highlighted the similar problem. And if these kind of problems exist when you're looking for orders to claw back monies that have left the company, which ought not to have in the very first instance, then you're not looking at the NCLT or the NCLT being able to do justice and actually issue orders for these monies to get reversed or the transactions to be set aside. So one has to be very careful while undertaking this audit. Also, there's a lot of importance, or rather a lot of mandatory requirements on the resolution professional also to form an independent opinion, judgments to that effect. So it's not the case that you just prepare a transaction audit report and you say a whole bunch of things and the resolution professional can blindly just submit it. You know, we are still an evolving jurisdiction, and as the judgments are coming out, there is a lot of learning involved. So the learning is that after the transaction audit report is actually handed over to the resolution professional, you also, as a resolution professional, need to form an independent opinion. And all of that actually comes together when you file an application before the NCLT. So we're not talking about the Insolvency and Bankruptcy Code. Obviously, the adjudicating authority for the Insolvency and Bankruptcy Code is the National Company Law Tribunal, with appeals to the NCLT and thereafter final appeal before the Supreme Court. Now, as far as preferential transactions are concerned, I don't know, most of you may have read or heard, the newspapers did report, the resolution process of JP Infratech is actually the prime case law as far as preferential transactions are concerned. In fact, it also did have an element of undervalued transactions. This was the biggest one, and something that Vijendra has a habit of saying, and I think it actually works well. Abhigyan and I, as well as VP, were involved in this fight. We did appear for a bunch of banks. We lost. But while I said that we lost, VP turned around and said that we actually learned a lot. And maybe which is why we can hold this session for you. Okay, maybe otherwise we couldn't have been able to hold this session for you. Preferential transactions, twin tests. The first test is, obviously, before we come to the test, who is supposed to highlight these transactions? We already know that it's the resolution professional or the liquidator, depending the stage of the process, of the insolvency process of a particular corporate debtor. The twin test is that first, there has to be a transfer on account of an antecedent financial or operation debt, which means there has to be a prior debt, be it financial or operational debt, of the corporate debtor. And because that there is already an existing debt, a prior debt, that particular creditor to whom the debt is owed has been given a preference over all other creditors. Now, how do you find out that somebody is given a preference above someone else? The code itself will give you the answer. It says that if you're breaching or breaking the waterfall mechanism, the waterfall mechanism actually is covered under section 53. And obviously, as I said, that these sections are so heavy, I just did not want to put all of them on the slides, but for your purposes, it's section 53. So section 53, if you go through it, you'll find that there is a lay provided. One of them, the first one is obviously the costs for insolvency, followed by workmen dues, followed by secure creditor dues, which is the pari passu, employee dues, so on and so forth. Now assume you suddenly make a payment to an operational creditor, okay, above a secured creditor. Clearly it's going to catch the eye of the resolution professional. But should all of them come under a transaction audit report? No, the law will also give you an answer to that. And in that answer, you will find that it is going to say that if it happens during the regular course of business. So when you read all these provisions, be it preferential, be it undervalued or extortionate, you'll also find the defenses set out. Sometimes it is the intent. Sometimes it is good faith. Sometimes it is regular course of business. Okay. Now you come to undervalued transactions. Obviously, undervalued transactions are quite unique because what you end up doing is trying to put away an asset out of reach of somebody, and thereafter, and out of reach of the creditors of this particular company. And while you're doing that, you're also actually charging them less. Now, you are already talking about a distressed company. So if the money that you have charged over a period of time is less, then clearly that ought not to have happened. Now, when an undervalued transaction is identified, the RP also needs to ensure that as far as the transaction auditors are concerned, they've also taken market, they've done a market research and they have comparables. So that's how you go around protecting it. Now, extortionate credit transactions. Now, this is quite unique because over here, the recipient is actually the corporate debtor. And what happens? You actually avail of funds, but what you end up doing is when you're repaying the funds, you're actually paying, as an example, a very high rate of interest. Now, you can always say that a bank or a financial institution will not be charging an unnecessarily unregulated high rate of interest. So what if you took the loan from a particular related company and you decided that you're going to pay them somewhere about 20% interest, which clearly is not the market ethos. So that's when you get captured within the fold of this. Now, all of this needs to be identified. Then you have transactions defrauding creditors. Now comes the word fraud, right? So for transactions defrauding creditors, what happens is, as I said, it's the resolution professional's duty to identify all of that. If the resolution professional fails, it does not mean that all hope is gone and everybody can fly under the radar. The creditors or the members of a company which is undergoing insolvency can also highlight such transactions. So there are a lot of protections built in law because the idea is to protect, preserve, and thereafter sell the company as a going concern to a third party. If you can't claw back assets, you can't recover value, then who is going to buy or give you adequate value, right? So which is why even creditors as well as shareholders of the company also can identify certain undervalued transactions should the RP fail to do it. Thereafter, you come to fraudulent and wrongful trading. These are targeted towards any person who knew that the company is undergoing financial distress, including the directors. When you read section 66, which brings in fraudulent and wrongful trading, you'll find that there's a specific stress even on the directors of a company, which also for people who are old-time practitioners of the Sikh Industries Act may sound very familiar. But be that as it may, even for fraudulent and wrongful trading, applications are to be preferred, which means that basically you have continued the operations of the company and continue to act in a manner pretending that there is no distress and you've not highlighted the distress and tried to resolve it. So very simplistically put, under all of these actions that the resolution professional can take, an application gets filed and relevant orders, which are mostly in the nature of setting aside, reversing, or clawing back the benefits, which also could be in the form of monies, gets passed. Then you have the separate segment, which is concealment of property on the slide, defrauding creditors and misconduct in the course of proceedings. These are visited by consequences, including imprisonment, including fine, or both. Now, the imprisonment can be anywhere between 1 year to 5 years, depending on whichever one you're invoking, be it concealment or defrauding or misconduct. And also the fine that you're looking at, the bandwidth is between 1 lakh to 1 crore. Now, interestingly, obviously, when these concealment or defrauding creditors or misconduct happens, you actually have to reach out to a separate mechanism. This takes you back to the Companies Act and the special courts, You're looking at the Chief Judicial Magistrate First Class and the Metropolitan Magistrates Court, whose doors you knock to get these sort of orders. Also, the look back period differs. Please go through them. It's about 1 year, and sometimes it's also even during the CIRP. Most importantly, over here, the person that you target while punishing is the officer of the company, distressed company itself, which is the corporate debtor. Can we please go on to the next slide? These are the nature of orders that are passed, but since I've already discussed, I'll pause here for a minute so that all of you can take a look at the same. But I've already discussed it along with the previous one since it was a natural consequence. So we can actually go over to the next slide. Yeah. Now comes the enforcement. See, while we know that the NCLT has a lot of powers to deal with anything that happens during the course of insolvency, during the course of resolution process, liquidation, and so on and so forth, you just can't be left with orders which bear no meaning. See, these are orders that most people, or at least under when these kind of applications get filed, they're heavily contested. And we have seen them in the case of Venus Recruiters, which was actually argued by AZB and Vijayendra and the team before you. They're heavily, heavily contested because nobody wants to be seen as doing wrong, okay? So the enforcement bit of it. Let's assume an application is filed. Let's assume you argue well. Let's assume the NCLT is convinced and they pass an order that yes, there are monies that are due and outstanding. There are monies that ought to be paid. The transactions ought to be reversed like it had never taken place in the first instance. But in order to do that, once the order comes out of the NCLT, are you hoping for everybody to toe the line? Maybe they won't, okay? And when they don't toe the line, what do? You can either approach the NCLT for contempt, or you can actually use the order passed by the NCLT. And now there is again a disconnect because certain NCLTs have actually gone in a separate direction. Certain NCLTs have held the line on some other direction. One line of judgment say that the order that is passed by the NCLT can be treated to be a decree of the civil court, which means for any lawyers who are practicing advocates, they will be well aware of Order 21 under the CPC, the Civil Procedure Code, which means that you can move into execution. The NCLT itself can start executing its orders, including passing orders like attachment before judgment and protecting assets, including passing orders, various orders, attachment being one of them, right? The other line of judgments that we have say, sorry, no can do, because the NCLT is a creature which has come out from the belly of the Companies Act. And instead, what we are going to say is if these orders get passed, they're going to be held as an actionable claim, which in turn takes you back to the definition of property under the IBC itself. And IBC is a complete code in itself. So how can I just simply forget that and reach out and become a civil court while executing this, right? So I'm going to call it an actionable claim. I'm going to bring it within the definition of property. And thereafter, I'm going to start dealing with it like the RP, for example, now has to make it his or her duty to go around and catch hold of these assets and bring it within its fold. So we'll have to see how this plays out. You have these kind of judgment, but enforcement becomes very crucial. Now we'll quickly go over to cross-border insolvency because again, even I'm shooting the time limit is almost over. We were talking about enforcement in India. Obviously, you know that when you're dealing with certain big entities, they are going to have assets outside India. When we started the presentation, I said that the RP also has the power to look into assets that are outside India as well. Now, when there are assets outside India, you will need a very robust global system and mechanism to be in place to reach out to these assets instead of looking at the laws of each and every jurisdiction where their assets are and file civil suits over there as per its own laws, get familiar, go through the entire rigmarole of continuing with a proceeding that is entirely foreign to you. And for that, we need the cross-border insolvency. Obviously, we have the provisions in the Insolvency and Bankruptcy Code. They have been notified, but what we need is the mode and the mechanics of it. We are hoping with each passing session of the parliament that takes place that at some point this is going to happen. And I am very hopeful because the government clearly has its heart in the right place. I just wanted to work out such that the next session that we have, should Mondak call us for it, then and should you all join, we'll have more of an update for you. So that's from my end, and Abhigyan is going to now tell you about fraud and asset tracing under arbitration. Thank you so much.
Thank you, Anindita. I know I'm bringing up the rear, but I will try to do as much as I can in the time that's available. So I'm going to talk about fraud in the context of arbitration, and then I'm going to move into asset tracing and talk about the elements of asset tracing, and also try and explain certain tools that we have in Indian law, which will help a potential award creditor to finally get what he bargained for, which is the money under the award. And most of our colleagues from perhaps other jurisdictions which are common law in nature would see that these tools are quite familiar to them. Now, most high value commercial contracts provide for arbitration. So the question is whether you're arbitrating in India or you're trying to enforce your award in India. And the question would be whether you can arbitrate issues relating to fraud. And while the Indian Supreme Court did go in different directions at first, over the last 4 years, happily, the Supreme Court has quite clearly held that allegations of fraud are arbitrable. Of course, the Supreme Court has said that there are two exceptions. One, that the fraud alleged does not vitiate the arbitration agreement. So one example could be perhaps forgery in the making of the contract. And if there is an arbitration clause in that contract, then there would be an allegation that would vitiate the arbitration agreement itself, and that perhaps cannot be arbitrable. That's one aspect. And the other aspect is, of course, that allegations which are criminal in nature, which VP was talking about, are not arbitrable because those would be before criminal courts or special courts which have been constituted under other criminal statutes. So what you've seen right now is that, of course, that the Indian Supreme Court has taken a hands-off approach in relation to arbitrating fraud. But at the same time, the Indian Parliament has taken a very hands-on approach when it comes to the impact of fraud on an arbitral award. So could we have the next slide, please? So in 2021, the Indian Parliament amended Section 36 of the Arbitration Act and said that an Indian court would unconditionally stay an arbitral award if it could be made out prima facie that the arbitration agreement or contract, which was the basis of the award, or the making of the award, was induced or affected by fraud or corruption. The Supreme Court has said that if that is indeed the case, then this would conflict with fundamental policy of Indian law, and such an award cannot be enforced. There is a very famous case now of the Supreme Court, Indian Supreme Court, on this issue. So could we have the next slide, please? And that is the Devas versus Antrix dispute. So just to give you a 2-minute background on this issue, the Supreme Court said that the company, a joint venture, was formed as a result of fraud and corruption. Therefore, the making of the contract itself, the formation of the joint venture company, was a result of fraud and corruption. And any arbitral award which emanated from that joint venture company or issues relating to that joint venture company was essentially impacted by fraud and corruption and could not be enforced in India. This, therefore, was something that the Supreme Court held was a nullity, and it was in conflict with fundamental policy of Indian law. And this is an example of an Indian court saying that an award is not enforceable because it is a result of fraud. At the same time, in parallel, we have the Amazon and Future saga, where we've had a lot of interesting issues being decided. One, of course, as you know, is the emergency arbitrator issue. But another issue which came to light last year was whether a party could rely on the decision of a regulator, where the decision said that there had been fraud in relation to representation before the regulator, whether those observations of the regulator could be relied upon to terminate the arbitral proceedings. Future made an application under section 32 of the Arbitration Act. Sorry, I forgot to see next slide, so maybe we could just have that. Yes, so Future made an application under section 32 of the Arbitration Act and asked the arbitral tribunal to terminate the arbitral proceedings. The arbitral tribunal refused to do that and said that allegations of fraud are arbitrable in any case that did not go into the root of the arbitration agreement. What Future did was Future filed a petition before the Delhi High Court, essentially raising the same issues. And the Delhi High Court agreed with the arbitral tribunal and said that Future could not raise these issues at this time and had to await the final award. Could we have the next slide, please? So I've dealt with the issues relating to fraud in as briefly as was possible, but let me go into asset tracing. And the elements of asset tracing are, again, very familiar to you. You've got an arbitral award, and I think the question that comes to your mind is, and what you're essentially thinking is, show me the money, as that line goes in Jerry Maguire. So what do? You think about identifying the ownership of the assets. You try and unravel the layering of entities to ascertain the ownership, the structure of ownership, because most assets would be through a layered ownership structure. You would try to determine the quantum of wealth amongst the asset classes. So, for example, certain assets may not fetch you the returns that you would want. Certain assets may be encumbered, and therefore they may be of little value. You would also try and analyze the movement of money, of how money was moving through companies, essentially to get to that money. You would also try and see if there were other investments by the the award debtor, to see whether you could get to those investments. And ultimately, you would want to see the proof of ultimate beneficial ownership, because mostly if you don't get what you want through the assets primarily held by the award debtor, you would want to have other tools to see whether through companies or through the individuals you could get to other assets. Now, of course, please have the next slide. Now, of course, there are challenges. I mean, the webinar is titled "Challenges in Relation to Fraud and Asset Tracing," so we would be dishonest in saying that there are no challenges in India. There are challenges. In fact, the numbers are quite grave. 1.5 million execution petitions are pending in lower courts, and the number in the high courts perhaps is higher. Defendants who have lost the award employ a number of tactics, and we've seen this in through our experience at the courts, which is try and re-argue the merits at the execution stage, perhaps use insolvency proceedings as a shield, and something that Ananta would be well aware of, and again file collateral proceedings, or use perhaps decisions of regulators in trying to scuttle the award that has been rendered against them. The practical issues that you may face are, of course, that some assets may be encumbered, third-party rights may be created to defeat the award, and your counterparties may try and divest their assets either locally or through other jurisdictions. So what do you do in those cases? The Supreme Court, can we have the next slide, please? The Supreme Court very recently actually had to step in because of these issues, and said in no uncertain terms that these are the guidelines that courts should follow in determining execution requests. And first and foremost is that the executing court should not go beyond the decree. So therefore, issues relating to the merits of the award can't be entertained by the executing court. The primary issue here is really the timelines. So the Supreme Court said that the executing court must dispose of the execution proceeding within 6 months from the date of filing, which may be extended only by recording reasons in writing for such delay. Now, whether Indian courts are following this in letter and spirit is something that we are still looking at, we are still examining. But at least in terms of guidelines, is a good guidelines to have, so that there is investor confidence which is created around the world to say that if you can have a definitive timeline within which you can get to the money. The Supreme Court also said that the court should allow evidence during the execution proceedings only in exceptional and rare cases. Could we have the next slide, please? The court also said that if third parties come in and try to intervene, the court should really not entertain them unless there are exceptional situations. The court also said that in a suit for payment of money, the judgment debtor should be asked to disclose his assets on oath to the extent that he's liable. And of course, there are also situations where there are apprehensions that the judgment debtor would dispose of the assets. And in those cases, the court may ask the judgment debtor to demand to deposit security to the satisfaction of the decree. Could we have the next slide, please? Now, in terms of execution, there are certain tools that are available under the Indian Civil Procedure Code. And I would want to sort of classify them as in three parts. First is you have to find out the means of knowing the assets that the judgment debtor would have. So Order 21, Rule 41 sets out perhaps getting to know the means through which the judgment debtor has the assets. Order 21, Rule 41(2) gives you a mechanism to understand what those assets are. And finally, if a judgment debtor is not complying, then unfortunately you will have to try and use the procedure of court in cases of disobedience, and you would have to then ask the court to imprison such recalcitrant parties. Could we have the next slide, please? Again, in terms of tools for interim protection while your award is being executed, you would want perhaps a freezing injunction, which is usually granted by courts as a matter of course after you've got your award, such that a defendant is not allowed to alienate his properties pending the execution. Another option that is available is the appointment of a receiver who would be appointed to receive and preserve the property of fund in litigation. And essentially, by doing so, the court actually removes the party in question from holding possession of that property. The next slide, please. Mareva injunctions are well known to English lawyers, and in fact, all common law lawyers. And the way Mareva injunctions are interpreted under Indian law is through this tool called attachment before judgment. This is a tool available under Indian Civil Procedure Code where, in case there is a real risk of dissipation of assets by a defendant either before an award is rendered or even after an award is rendered, the court would be inclined to attach the properties of the defendant to the extent of the claim in the arbitration, perhaps, or to the extent of the decree which has already been given. This is not an ordinary remedy, and Indian courts have quite recently also held that it is only in extraordinary circumstances that such a remedy is going to be allowed. Now, one question that is asked quite frequently is, how do we, in cases where there are foreign proceedings, how do Indian courts support those foreign proceedings? Well, in Indian law, unlike in England or Singapore, you can't file a bare civil claim for injunction. That is not possible under Indian law. So I cannot approach an Indian court under a civil claim for an injunction to support a foreign proceeding. But here's what you can do. Under the Arbitration Act, Section 9 is available, and even for a foreign proceeding, the option of going to a Section 9 court in India is still available, which will support the foreign proceeding in terms of giving interim relief to support that foreign proceeding or the foreign party, and that award may or may not be enforced in that the other jurisdiction, depending on the laws of that jurisdiction. But the Arbitration Act does give that option. Could we have the next slide, please? So finally, the other tools, the remaining tools that are available are Anton Pillar orders, which are really search orders for search and seizure of relevant materials and documents. The primary purpose for this is to preserve evidence which may be in danger of destruction or concealment. And the other option that is available is to appoint commissioners, local commissioners, to conduct investigations or perhaps do raids to seize counterfeit devices, counterfeit goods, and we see this a lot in intellectual property claims. So I think I have been very fast, but I have managed to finish almost in time. So I have nothing further to say. So I'll hand it back to VP and Dan.
You did say a lot, by the way.
Thank you very much, Abhinayant. No, I want to thank you all for your expertise and your insights today. Such an incredibly informative webinar, and as you say, we've come in just a little bit ahead of over time, but we have had a question in from the audience that I want to ask you before we finish. Can assets be recovered and third party be proceeded against if assets have been squandered away to third parties during the pendency of the proceedings? You should be able to see that question in our chat.
Yes. I do have an answer from an insolvency and bankruptcy point of view. So I'll quickly give that because it says during and before. So I guess it's from an insolvency bankruptcy code point of view. So during the process, if there is squandering away, obviously you are looking at proceedings that you bring about. So when you read section 68 and 69 and 70 of the Insolvency and Bankruptcy Code, it does provide protection, but it is aimed only at punishing to the corporate debtor. What is very crucial to note is if it is happening during insolvency proceedings, it means that the resolution professional has either been lax or is hands in glove. So you're looking at disciplinary proceedings being initiated by the regulator, which is the Insolvency and Bankruptcy Board of India, and thereafter appropriate orders being passed for these assets to be brought within the fold. So you're looking at a whole gamut of actions before not only the NCLT, not only directed at the corporate debtors and officers who are hands in glove, you're looking at the resolution professional, because if it's happening during, it's a problem for him or her who's been appointed, including inviting disciplinary proceedings and thereafter the final application to NCLT to get it back. Yeah. So you're looking at section 68, 69, 70, plus the rules and regulations that provide for disciplinary action to be taken against the RP.
Only because Abhinayant didn't get to speak, I'm going to let him answer this one.
Okay. All right.
Right. So I'll answer it. If third-party rights are being created to defeat the enforcement of an award or the enforcement of an order, common law provides that those rights can be sort of held as a nullity. Those rights can be reversed. The Indian Supreme Court has recognized that common law principle, including very recently in a judgment called Sitaram vs. Balbir. I think this is 2015 or 2016 judgment, in which the Supreme Court has held that if third-party rights are being created to defeat the award, then such third-party rights will not be recognized. Of course, the question then is of fact, whether the third party had knowledge, constructive or real, of the fact that there was an award or a judgment. That question will still have to be looked into. But as a matter of principle, it is possible for such third-party rights to be de-recognized.
Brilliant.
I hope that
Excellent. Thank you very much. I know that we still have a few questions to get through, but we will have to wrap it up at this time now. We're 5 minutes over the hour, but I just want to say thank you very much to our wonderful panel today for their insights. Vinyan, Vijendra and Andita, really appreciate having you with us today. Hopefully we'll be able to have you back soon for another webinar, but thank you very much to our audience as well for being with us today. But I will say thank you very much again and goodbye for today. Hope you have a lovely rest of your day.